Hello and welcome. I'm Ankur Mishra and this is a special show on ET Now. Anil Ambani, once at the helm of India's most powerful business empires, is now under ED's scanner. The agency has carried out sweeping raids across multiple Mumbai properties in connection with an alleged money laundering probe and alleged foreign asset holdings. But this isn't new for India. From Vijay Mallya to Nirav Modi and Mehul Choksi, the list is long. We have seen several high-profile names make headlines, often after banks have flagged alleged massive frauds. So the big question we are asking, with action now reaching Anil Ambani, is this meaningful enforcement or simply too late, too little? Joining me for this special discussion, we have three important guests. Sanjay Hegde will join in a short while. We also have Sriram Subramanian, founder and MD in Govern, and we also have HP Ranina, senior lawyer at Supreme Court of India. We'll come to you, gentlemen, but before that, let us also hear out what Prime Minister Narendra Modi said about extradition of few of the offenders to India. He maintained that agencies will cooperate on the same. Let's listen in.
इस बात पर भी सहमत है कि एक्सट्रीमिस्ट विचारधारा वाली शक्तियों को डेमोक्रेटिक फ्रीडम का दुरुपयोग नहीं करने दिया जा सकता. Those who misuse democratic freedoms to undermine democracy itself must be held account. इकोनॉमिक ऑफेंडर्स के प्रत्यार्पण के विषय पर भी हमारी एजेंसी सहयोग और समन्वय से काम करती रहेगी.
All right, so this was Prime Minister Narendra Modi detailing this. Yes, India is looking for extradition of economic offenders, and yes, the steps are being taken and agencies will cooperate for the same. Gentlemen, once again, welcome to the show. Mr. Hegde, welcome. First, I want to come to you for a reaction. Do you think in this particular case where now ED has come into action, how will this strengthen the case for investigative agencies, and do you think they have acted a little late?
Well, the ED having come in, has brought in a different procedure altogether. If, for instance, they decide to arrest somebody, then getting bail in a PMLA case is much tougher. So the ED is normally set out on people when you want to exercise teeth. The normal law and the normal procedure under which prevention of corruption, etc., are tried. There normally, even if the investigating agencies decide to arrest somebody, bail is granted and things like that. The ED getting in essentially says that there was a predicate offense. The predicate offense was that of bribery, forgery, etc. The proceeds of crime have been laundered by whoever the accused that they are investigating, and the ED has much greater scope to investigate, especially in matters of custody. I think that this is a development that no industrial house normally would be seen as welcoming.
All right, that's a view coming in from Mr. Hegde. I want to come to you, Mr. Ranina. Legally, what weight do these ED raids carry at this stage?
Well, the ED raids are meant specially for investigation to find out the facts. These are what we call search and seizure, both under income tax law and the Enforcement Directorate law. So these are to fact finding. So the raids are undertaken to make sure that the facts have been disclosed or are being, whatever concealment has been done is now being shown and out in the open. So the raids are meant to collect evidence. And therefore, it is still a little premature to determine whether the guilt is established or not. That will ultimately go on for many years in a court of law. But currently, it is a fact-finding mission of the Enforcement Directorate, getting the documents, getting people to give their statements, giving them an opportunity of being heard, so that after the fact-finding mission is over, then of course the charge sheets may be filed and presented in court, and then action may be taken. So this is the first step. And to answer your first question, which you had put to Mr. Hegde, is it too soon? Is it too early? The answer is, whether it's early or not, you have to undertake the job that you are given. And therefore, I think it's a step in the right direction. The object is to show that, look, we are going to take action, however high and mighty you may be. And therefore, whether it is early or late, we are going to take action against you. And the long arm of the law will catch up with you in case you have done something wrong.
Right, Mr. Ranina, but this is a case which is more than 10 years old, and even at that period, a proper procedure was followed. I'm talking about Yes Bank case, I'm referring to PNB. All these cases have been flagged by banks for many years, in fact 8 to 10 years to be precise, and even the insolvency process was started. Mr. Subramanian, I want to come to you here. Banks have already taken the hit. All these cases, whether you talk about Reliance Home Finance, you talk about Reliance Communications, you talk about Mehul Choksi case where PNB has taken a hit. So all these banks have already taken a hit. What is the point of action which is being taken now?
The fact that banks have taken a hit doesn't mean that wrongdoing should go unpunished. Two is definitely there is a 10-year lag. If you see the investigative agencies, the same case, SEBI has come down and barred Anil Ambani from the securities market in April 2024. That has been challenged in the SAT, and I think it's still pending. But at the end of the day, that order was with respect to the same case where funds were taken away by the promoter from Reliance Housing Finance Limited, etc. So whereas ED's perspective is slightly different here, it is bribery of bank officials, bribery of S Bank promoter Rana Kapoor, etc. So the perspective is different. SBI, that is the State Bank of India, and Canara Bank, after a forensic audit, have marked the group as fraud accounts. So to that extent, public sector banks and other commercial banks cannot lend money to the ADAG group companies. So as by RBI norms. So that's where the investigations stand. But that doesn't mean that the ED should not pursue these cases.
Definitely, investigative agencies have now come into action, and these are just allegations at this stage. We don't know what is the result of those fact findings. But Mr. Hegde, what procedural steps which ED takes currently so that they can build a strong case? But because what we have seen till now, all these cases are hanging in courts and no results have been there.
See, the ED's powers have been used so far against politicians and other people that the government doesn't like. This is interesting when it comes to people, when it comes to industries who are still seen as being within the charmed circle. The power of the ED, as I told you earlier, is the ability to arrest it during the course of its investigation, and when bail is sought, then the judge has to be prima facie satisfied that no offense is made out and that you're not likely to repeat the offense. So when any of the people who are accused in an ED case will tell you how terrified they are of the power of the ED to arrest. As long as no arrest takes place, and in Mr. Ranina's words, if there is an initial survey and a fact finding and all that, and then the ECIR proceeds to file a charge sheet and then it goes into trial, that is something with which nobody can really have any kind of problem. The real issue is if the ED has instructions or decides that it has to be seen as having done something substantial, going after the fat cats, that is when trouble will hit the fan.
Definitely, Mr. Subramanian, now I want to understand from you, banks have early warning signals which we have strengthened over the years. But now enforcement agencies are acting after banks have red flagged account, they have declared as fraud. So are these early warning signals kind of broken? I want to ask you here because there is a procedure which is put in place, but it is also delayed kind of actions.
As far as bank processes are concerned, if the top promoter of the bank is involved, like in the case of S Bank, where Rana Kapoor himself sort of overlooked sanctioning of loans, or in the case of public sector banks like SBI and Canara Bank and other banks, there is phone banking where some politician is calling or to pull a favor, etc., etc., and then all the processes get destroyed. Nothing is up for grabs. I mean, so even the credit committee's proposals are not even looked into. Whether the project has merit or no merit, that is not looked into. Just a phone call, those were the yesterdays when just a phone call and the CEO of the bank would sanction hundreds of crores for a fee which the bank either will make or the promoter will make on a personal side, and that was the case. And this is a corrupt system which hopefully is now corrected. There could, at least at a large scale, it has been corrected.
Right, at least the action has begun, but in between we have also taken several actions. Insolvency process started. In fact, after 2016 there has been much of the recovery by the banks, and this is the best process available till now for banks, and they have also been empowered with declaring fraud, reporting to agencies. All these steps have been taken, but more importantly, Mr. Renina, I want to understand from here on, ED raids have happened, particularly about this case. What is the next procedure? Do you think that there is a possibility that banks might still recover their money?
Yeah, the issue is not of recovery. The issue is of punishment. That if a person has been found to be guilty of an offense, then the punishment will follow as per the law. So, the punishment is more of a personal nature, like money laundering. If a person has made money, then his money will be recovered, not the banks, but his money will be recovered. Now, the banks may have written off, banks have their own procedure. That's a separate issue. So under the Money Laundering Act, under the Prevention of Corruption Act, these are all punitive measures to punish the wrongdoer. Simply because the bank has recovered the money or part of the money does not mean that the wrongdoing has been wiped out. It still means that the person who is guilty of the wrongdoing has to be brought to book. That is the whole object of these laws, to prevent people from indulging in these activities. And therefore, these type of activities will continue, even though the bank may not be involved. But if people have been found to have made money, illegal money, then the question of punishment will come in. Recovery from them will take place. All these are under the law. So the Enforcement Directorate, CBI, and others are all concerned with ensuring that the law is obeyed and the law is brought to justice. The people who are guilty are brought to justice. Maybe it happens after 7 years, 8 years, 10 years, but the time is not a factor in these matters. If there's an offense, then they are to be brought to justice.
Certainly, if there is an offense, investigative agencies are now in action. Mr. Hegde, you also heard Prime Minister Narendra Modi talking about extradition. What is your sense? We have been waiting for extradition for years. In fact, concrete steps have been taken. Now even Prime Minister has announced that coordinated efforts are made by investigative agencies. What do you think are the procedural roadblocks here?
No, it is almost impossible to extradite somebody from a European country, and particularly Britain. Because even if the government there allows an extradition, that is subject to judicial review. And judicial review is based on several factors, including the kind of treatment that the offender could possibly face in the country to which he is being extradited. On a different note, you may remember that when Abu Salem got extradited from Portugal, India had to give an undertaking that he would not be put to death, nor imprisonment beyond 25 years. So today, Mr. Salem from his prison says that I've almost finished 25 years, now let me out. There have been others, including Mr. Verma in the War Room leak case, who have won their cases in the British courts on the basis of conditions in Indian jails. So while the administrations of the two countries may agree on extradition, often it happens that the person sought to be extradited gets relief from the courts in the UK, and they also have a fallback plan of having citizenship of some other vague country. You may remember that in the Mehul Choksi case, he had citizenship of Antigua, if memory serves me right.
Right. In fact, all those steps have been taken. What is your sense, Mr. Ranina? Do you think there is a possibility of extradition, or do you hold the view which Mr. Hegde is having?
No, Mr. Hegde is absolutely right. The important point is it's not the Prime Minister or the administration which decides. It's the courts of law in those countries which decide. So extradition can only be done if the courts agree. And therefore, both Vijay Mallya and all the others have gone to court. They have taken the protection of the court. And the court has been told that there will be problems in India and they will not be treated properly, etc., which is absolutely not correct. I think in India also prisoners are treated quite fairly. But the judges there are being influenced by saying that they will be mistreated or something will happen, that will happen. And therefore, the extradition process is stalled. So I don't think it has anything to do with the administration or the governments of the two countries, entirely the judicial process. And if we can succeed judicially, then we can get extradition. Otherwise, we will not get it. That is the point.
All right, that is a view coming in from Mr. Ranina. Mr. Subramanian, let's come to facts. Till now, we have seen the action which has been taken by investigative agencies. Prime Minister has at least given assurance from that forum that efforts are being made and coordinated efforts are being made. Where do you think there is a lapse as far as banking process and insolvency is concerned? Because end of the day, the whole process started because there was fraud. The whole process started because banks want to recover money. Do you still see the possibility?
Recovering money these days is anyway gone to the IBC. If there is these kind of explicit frauds where the promoter has taken away funds, it is almost well nigh impossible to recover funds, especially since it's PMLA case where the funds may have moved out of India and tracing the route of the funds may be difficult. So at the end of the day, for banks, the only good thing is today our banking sector is fairly clean. Banks have cleaner books and compared to what they were about 10 years ago. So from that perspective, the NPAs, write-offs and all have happened, and banks are much more looking at much more credit-worthy businessmen and much more credit-worthy projects to lend to, I would think.
All right. Also, I want to understand there is a possibility we can see that more investigative agencies may be involved. Do you think that kind of possibility is there, Mr. Ranina?
Of course, if something has been found which violates another law, then certainly that agency will come into the picture. So apart from, say, money laundering, the question will be of income tax, that you have not paid tax on that money, because under the income tax law, whether you earn income legally or illegally, you still have to pay tax. There's no exemption for illegal income. Therefore, income tax authorities will also step in due course. And maybe there may be other investigative agencies, but main thing is money laundering, sending the money abroad. Therefore, Enforcement Directorate is involved. If obviously there's no tax paid on that money, therefore income tax will be involved, and therefore all agencies will certainly exercise rights under their respective laws.
Also, what we need to do right now is to find solutions. Let me clarify here to viewers, even there has been releases by Reliance group companies, and I'm talking about ADAG group companies. Reliance Infrastructure has clarified, Reliance Power has clarified that there is no impact which is bearing on these companies because these cases are more than 10 years old. And here I want Mr. Subramaniam, what lessons do you think we should learn from these episodes, and do you believe that next time when anything like this happens, because cases will happen, what learnings we can take?
It's a question of who you say as we. I mean, the banking system, of course, banks have to safeguard their own interests by being lending to creditworthy individuals and creditworthy projects. The system as a whole has to function. That is, RBI scrutiny, banks and NPA classification, etc., should be much more, I would say, stringent. And RBI obviously does its job, I would think, fairly diligently these days. 3 is phone banking, of course, should be cut down as a system. 4 is if there is a this one of a scam, sense of a scam, the investigative agency should act faster. I mean, not 10 years, not even 1 year, 2 years. I mean, why can't it be investigated faster is all I'm saying.
Mr. Ranina, yes, after 10 years, investigative agencies have taken a note and acted on that, and that too happened after State Bank of India, Canara Bank declared these accounts as fraud and individually named Mr. Anil Ambani. Do you think as a process we need to add few things, especially in IBC, or there is a procedural gap which we have between investigative agencies and banks action?
Well, as far as the bank is concerned and the IBC is concerned, one of the biggest problems is the backlog of cases. There are not enough judges today, even in the IBC or even in the NCLT. This is a big problem, and that is something which the government can certainly act and appoint more judges and make sure that the system is expedited. That is one. The other is the issue of getting the evidence. It takes time to collect evidence. And therefore, now you find that enforcement director has come in because of CBI inquiry revealing certain facts. So that is where the time lag comes in. But of course, we have to speed it up. We have to use modern methods like artificial intelligence and other tools of technology to make sure that these can be expedited in the shortest possible time. So I think there's a lot of room for, to ensure that things are done at the right time so that people are brought to book, because as you know, justice delayed is justice denied both ways. And therefore, the sooner the matter is over, the sooner the investigation is completed, the sooner the process of law takes place, I think it is good for the country as well.
Right, that is a point well taken. Mr. Hegde, I want to come to you. Now, we are sitting at a situation where ED has at least started the process of fact finding. They find or not, that's a secondary issue. What I want to know is a bigger question, that step has been taken. Do you think in future the learnings should be there from this case, PNB case and other cases which have been in recent past? And more importantly, there is other side as well. Mr. Vijay Mallya has maintained that he has returned the money. Mr. Anil Ambani has been maintaining through their lawyers, they have sent a letter to State Bank of India stating that the company is under insolvency. Is talking about Reliance Communications, and there was not opportunity which was given to him. So do you think that other sides has also valid reasons and law will hear both the sides and come to conclusion?
See, it is not criminal to make a business loss. But in the course of business, you can certainly be criminal. Enron went down due to criminality on the part of many of its key personnel. You saw it happen with Arthur Andersen. many companies indulge in behavior which, when not properly explained, can also be termed criminal. So to check for criminality, prosecutions happen. Now, in this particular case of Reliance, what is the allegation? The allegation is that they took loans from Yes Bank, and in the meanwhile, another group company advanced personal loans to companies associated with the chairman of Yes Bank. So it was a round tripping of some portion of the money, and there was obviously bribery involved. At least that is what the investigation by the CBI has shown. Now, once the Enforcement Directorate comes in, the legitimizing of that money turns into money laundering, and any assets which are acquired out of such money laundering become the proceeds of crime. The Enforcement Directorate can move against those assets, attach them, and later, if the prosecution succeeds, even sell them to recover the money. So every person accused of a crime will have a defense. Every person may say that I did not do it the way the prosecution says it, but those are matters which are finally churned out at the trial. Mere returning of the money does not wash away criminality. Mere loss does not establish criminality either.
With this, it's time for a wrap in this edition of a special show. Thank you, gentlemen, for joining at this hour and sharing your views. Definitely, both sides should be heard. And as far as Anil Ambani Group is concerned, we have been telling that they have been given to understand that they are maintaining that cases are more than 8 to 10 years old, as I discussed earlier, and they have also sent letters to State Bank of India maintaining their view that they have fully repaid the money. But with this, it's time for a wrap. Thank you so much for tuning in, and we'll keep bringing the updates in the matter.